Welcome. Thank you for joining us this evening. My name is Jessica Coote. I'm the practice leader of the Illawarra office of Watts Macrae Lawyers. Next slide, please. I'd firstly like to acknowledge how privileged I am to be joining everyone today from the land of the Wadi Wadi people in Wollongong, and we're part of the Dharawal Nation here. I acknowledge the traditional owners of this land and the lands that all of you are on across Australia, and I pay my respects to elders past and present, and extend those respects to any Aboriginal and Torres Strait Islander people joining us online today. This land is, was, and always will be Aboriginal land. Just a quick introduction about Watts Macrae Lawyers. We have been around for over 40 years. We have several offices across New South Wales, and we are also a part of a larger organisation, being Australian Family Lawyers, who are a national family law firm. So we have offices all across Australia. We practice exclusively in family law. We do have some other side branches that do some criminal law and disputed estates, but our main focus is providing legal advice to clients in the family law space, including divorce, separation, children's matters, property settlements, and those areas. Just briefly about me, I've been practicing as a solicitor predominantly in family law for over 10 years, but I've been in the legal industry for over 20 years. So I've worked in lots of different roles as supporting and paralegal, and then studied as a mature age student doing my law degree. I've lived in the Illawarra in Wollongong my whole life. I'm a mum, a stepmum, part of a blended family, so I get it. And I also do a lot of not-for-profit work, particularly for the Illawarra Women's Health Centre, and we've just established the first ever Women's Trauma Recovery Centre here in the Illawarra, and also former chairwoman for the Illawarra chapter of the Women Lawyers Association. So that's a little bit about me. Next slide, please. On the agenda today, we've only got a little bit of time, so it's going to be jam-packed, but what we're hoping to achieve with you today is to explain the law and the processes around family law property settlements in Australia. Please keep in mind, and we need to always say this as lawyers, that this is not intended to constitute legal advice in any way. It's really important, particularly in family law, that we know and understand your particular facts and circumstances of your own case. So we can't provide you with any legal advice specifically. The purpose of this is really to give you an overview of the process and a better understanding of the process and how it works. We also haven't vetted our audience. We don't know a whole heap about you. So we need to be careful of any conflicts of interest with our current clients across Australia. So we won't be able to give you any specific advice today, but we do encourage you to get in contact with us if you do have some questions that require answering around specific advice, and you'll have our contact details, and you're welcome to contact me at any time. Next slide, please. For property settlements, we have some guidance, and it's now been popped into the Family Law Act just recently with some amendments only about a week ago to the Family Law Act, but we do have some steps that we tend to follow. So what I'm going to do firstly is to work through these 5 steps with you to give you a better understanding of the steps that we take and the steps that the court takes when we're assessing what an overall fair and equitable settlement is for our clients in family law. And as you would expect, 50-50 is not always fair, as some people may feel that it is, when we're looking at all of these different circumstances for our respective clients. Next slide. The first step is whether or not it's appropriate to make an adjustment. And what we mean there is the court's going to have a look at and determine whether or not it's just and equitable to make any adjustments at all as part of the first step. The court will only alter property interests if the justice if justice requires it to do so. So generally in longer relationships where we've got kids and joint properties and a lot of intermingling there of finances and it's been a long relationship, usually it's quite easy to overcome this threshold. So where we tend to see these types of matters get up, where we can argue that it isn't appropriate to make any adjustment, or what we call a Stanford argument, where there's been perhaps a short relationship, no children together, and very separate finances. Next slide. Step 2, we have a look at and identify the asset pool, and this is where we're looking at what are the assets, what are the liabilities. Superannuation forms part of the pool of assets to be divided. So we've given a bit of a list, but it's really any assets and liabilities that have value. We also look at financial resources and ascertain, well, what are the financial resources that are relevant, if any, which may include entitlements as a beneficiary, for example, to a discretionary trust, or it may include things like a pending personal injury claim or an estate. Thank you. Step 3 is assessing the contributions made by the parties, and we'll go into some more detail about contributions because there are different types of contributions. So as you can see listed here, we've got financial contributions, but non-financial contributions are also very important, including homemaker and parenting contributions. And when the court is adjusting on contributions, they generally see that those homemaker and parenting roles as just as important as the income earning roles in a relationship. Next slide. So what are financial contributions? They're the easy ones to calculate. They're the ones where amounts of money have been contributed by a party towards the acquisition, maintenance, or improvement of assets. So they can either be at the commencement of a relationship or when the parties start living together, during the relationship and across the course of the relationship or marriage, and after the relationship as well, so post-separation contributions. We've listed here some examples of financial contributions. They may be that you had certain assets and debts at the commencement of cohabitation, income that you've brought in from your salary or other investments. It could be inheritances or contributions, lump sums that have come in, windfalls, gifts, lotto winnings, redundancies, compensation payouts. There's numerous sources that financial contributions can come from. And the weight given to the financial contributions is taken into consideration looking at the myriad of contributions is the terminology that the court uses. But you won't necessarily always get a dollar for dollar contribution for any lump sums such as an inheritance or a compensation payout that you bring in, and it's important to get specific legal advice from a family lawyer about what weight, if any, a court's going to put on that specific contribution that you have brought in. Next slide. We move to non-financial contributions, and we'll go into more detail on the others, so the homemaker and parent roles. But here we're really talking about contributions other than financial contributions. So things like examples of this may include improvements to property or renovations. So where you yourself have painted the walls, built a deck, done some landscaping, something that has specifically increased the value in the property, for example, or performing unpaid work in your partner's business. So often a wife may be doing work in a husband's business that's not necessarily paid, but she has contributed through that work that she's been doing. Researching investments, that's a little bit of a harder one to quantify, but these are examples of the non-financial contributions that we consider. Next slide. Homemaker contributions. So this is any contribution made in the capacity of homemaker. So here we're looking at those domestic duties that people are doing in the home. And this is really important, particularly where we may have a primary income earner and a primary homemaker, someone who's the agreement may be between the parties that one of them will be at home Often it may be the wife. And examples of those types of contributions include all of the things we do around the home to maintain the home, the cooking, cleaning, laundry, groceries, paying for bills, and those outdoor jobs like mowing lawns, gardening, maintaining the pool, for example. Next slide. And then there's parenting contributions, and arguably as a parent, I think they're probably one of the most challenging. And it's any contribution made in the capacity of a parent. So what we're trying to ascertain here is who had the primary parenting role, what were the roles, what was undertaken, who fed the babies, changed nappies, settled them, took them to appointments, played with them. And then as the children got older, those roles can often change as well. So who's taking them to and from extracurricular activities. And then what we can consider here as well is where there may be what we call a reverse parenting contribution, such as care for stepchildren. So you may have a stepchild that's lived with you full time, which can be relevant on contributions as well when we're looking at what percentage adjustment should be allocated to each party for their respective contributions. Next slide. Now on to the next step. So the next step is then looking at what are the parties' current and future needs. And when we're looking at what percentage adjustment, and we talk in terms of percentages for family law property settlements, when we're looking at what adjustment should the court give or what adjustment should we consider if we're finalising the matter outside of court to a party because they have greater current or future needs. So there's an extensive list here, but not everything's listed, but it's things like age, health issues, particularly if they impact your ability to work, income and financial resources, physical and mental capacity for employment, the impact of how a proposed division of assets and liabilities may have on a party's financial future there, the care and control of children, and recent amendment has also added in the need to provide appropriate housing for children as well as a consideration. Whether or not either party has any commitments to support themselves or another third person is also considered here. If a party is receiving a pension or government allowance, what is a reasonable standard of living for each of the parties? If an incapacity has been impacted, then that's relevant as well. The need to protect a party's interests where they wish to continue their role as that primary carer and parent. And that's an important one, particularly where we have stay-at-home parents. And with the recent changes, we had always considered family violence, but there's more of a focus now with the recent changes that have come through earlier this month, which us family lawyers are very happy about, on the impact of family violence on a party's current and future circumstances. But we really do need to show that link between the family violence and the impact on the current and future circumstances. And then in this part too, we may look at wastage by either party as well. Next slide. And the last step is the proposed division just and equitable? And this is where the court's discretion comes into it. And this is why often family lawyers are saying to their clients, look, we can give you a guideline based on all the other steps, but the judge does have a discretion as to whether or not they then alter it based upon what is just and equitable and what is fair. And this is a difficult concept to get your head around for our clients, but for us, what we're doing is constantly watching case law as it moves forward, and we're always looking at, what are the parties looking to retain? And often this is relevant where you might have one party saying, I'd prefer to keep more of the proceeds of sale, for example, in lieu of a super split. Well, what impact is that going to have then on the other party who gets less proceeds of sale and their superannuation's locked away for their future? Next slide. So let's talk through now the process that's involved in a property settlement matter. So we initially meet with our clients, and in the initial consultation with our clients, we'll discuss with them the overall process and the steps that need to be taken before we can get to formalising the agreement. Next slide. Huge part of the process, and I think a big frustration for our clients, is the exchange of financial disclosure documents in that process. So we have just had that codified with the recent changes as well to the legislation. However, it was in the rules previously. We've now got it in the Family Law Act as well. There is a duty of full and frank financial disclosure in family law matters, and that duty is ongoing until the matter is finalised. So there are certain documents that we need to exchange with the other party. Things like pay slips, tax returns, super statements, for example, and bank statements. Generally it's 2 years, but sometimes we go with a different time frame depending upon the circumstances. And the disclosure requirements don't only just cover assets that are here in Australia. It's important that all assets are disclosed, including overseas assets, as part of the disclosure process. It's a lot of paperwork, and we have some absolutely brilliant paralegals here at Watts McCrane Australian Family Lawyers, and my paralegal Sam is a whiz, and her jam is really getting clients' documents organised into a neat manner, and we send them over with schedules to the other party and exchange financial disclosure documents. The court requires this exchange to occur, and when we're formalising your agreement, we do need to sign off to say that this exchange of disclosure has occurred. And if you were to skip part of this process, it does generally put your agreement at risk. Next page. Negotiation. So we want to keep your matter out of court unless we need to be in the court system, and that's because we know how expensive the court process is, and we also know how timely and how long things take in the court process. So we'll be looking and canvassing with you lots of different ways that we can negotiate. So sometimes we have parties that come to us where they're amicable and say, we've reached an agreement between ourselves, this is what we've agreed, and we just get started on the exchange of disclosure and getting the agreement formalised, provided we'll advise on that agreement and it is within the range of what a court would otherwise order for those parties and their circumstances. We often exchange offers of settlement in writing between lawyers, so that's part of the first part of the process. And then if we're hitting a bit with those negotiations, we look at other options, such as, depending on who the lawyer is on the other side, perhaps a round table conference with the parties and their lawyers, or a mediation process where we have a third party mediator who is not someone who can make a decision, but can be someone that can help us talk through and canvass different options for resolving the matter. I think negotiation's important anyway, regardless, but we are required to make genuine attempts to resolve a matter before commencing court proceedings. And obviously there's some exceptions to that where there is urgency, family violence, other issues, which mean that we can't, it's not just as simple as having a mediation, but we offer a range of different options for our clients when it comes to mediation. And I do a lot of work with victim survivors of family violence, and a lot of them tell me often, and not always, but that they would prefer to mediate and to have ownership over the decision than not. So we're really then looking at how can we do that safely for clients, and we look at different options such as online shuttles, and there's lots of different options there that we can consider. Next page. And hopefully, without going to court, we reach an agreement. And if that's the case, there's two ways that we can formalise it to ensure that it's legally binding. The preference is generally through consent orders and an application for consent orders, specifically that we file with the Federal Circuit and Family Court of Australia online on their court portal. Filing fees, nothing huge. I'm not sure if it's going up at the end of financial year, but at the moment it's only $200. And what happens is we upload the application and the proposed orders to the court portal, and then a registrar is allocated across Australia, and it's no longer specific to registries. You have a registrar allocated to it, and they'll have a look at it in chambers, and provided that they find that the overall outcome's just and equitable and in light of the law sort of falls within that range of possible outcomes on percentages, generally the orders are then made in chambers. Sometimes we get a requisition with some more questions, and usually if we can't get consent orders through, our lawyers have already picked that up and put the client on notice that it may be difficult because it is outside of the range of what a court would otherwise do. The other option is a binding financial agreement, and we use BFAs often here for prenups, contracts during relationships as well. So you can already be married or can already be living together and may want to specify in a contract that you don't actually want to fall under the Family Law Act. Now, make sure you get some specific advice about it, about BFAs and the risks for you, because obviously they don't go to court. They're not formalised through the court like consent orders. So they do carry greater risk as far as potentially being overturned in the future. So that independent legal advice is really important with the BFA, but it is required anyway. You each have to have separate solicitors who sign off on the certificates. Next slide. And then we implement the agreement. So whether or not we're using a binding financial agreement or consent orders, or alternatively, if we have to go to court and a court makes orders, then the steps towards implementing the agreement step in. So your consent orders will set out what timeframes things need to happen in. Consent orders are a great way to get around things like stamp duty exemptions, where you're transferring a property from joint names to just one party's name, for example. But the orders will provide timelines for that to happen, superannuation splits, all sorts of things, removing parties from companies, paying out liabilities, transferring registration of vehicles, so you don't have to pay stamp duty on that transfer as well. And it is absolutely essential that a lawyer, particularly with the consent orders, drafts these to make sure that they are able to be implemented and also are enforceable in the event that something falls over through the enforcement phase. Next slide. Yeah, so what if an agreement's not reached? And it's not only when an agreement's not reached that we have to go to court or look at court or arbitration. Sometimes we have one party that might have their head in the sand, and we've sent several correspondences. Sometimes there's a benefit to one party to delay, particularly if they're in the home and the other party may be paying for the mortgage, for example. So we try to keep matters out of court, but sometimes they inevitably end up in court. Most matters, particularly property matters, will settle before a final defendant hearing anyway. There's different opportunities throughout the court process to participate in mediation, and we're continually making offers of settlement. As you would expect, going to court can be quite expensive. The process can be stressful, but we're here to alleviate as much stress as we can from you. And there are significant delays with the court system, so you can be waiting 3 to 4 months between court appearances and not much happening, particularly with property matters, because the priority of the court is often on those matters that are urgent, and parenting matters as well that can take priority. Arbitration is also an option for property settlements. And what arbitration is that you can appoint an arbitrator, a qualified arbitrator, to hear your matter rather than a judge hearing your matter, and to make it an overall decision. So we do consider arbitration to keep the matter out of court. Generally, you can get it done faster than litigation, but the processes and rules of evidence still apply. So it's generally still expensive and a similar stressful process. So we're trying to avoid parties getting to this point. However, sometimes commencing court proceedings can be what's needed to really give people that push along to get the process started. And then often we'll resolve the matter in the court process, and it may be through a mediation or a conciliation conference with the registrar of the court throughout the process. Next slide. So on the 10th of June, just last week, us family lawyers have been very busy getting on top of amendments. We did have some amendments to the Family Law Act last year that particularly impacted parenting. There were a number of amendments that particularly impact property this time around, and then some other amendments to divorce and other areas as well. But I'm just focusing here on the ones that impact family law property settlements. What they've tried to do with the amendments and the aim is really to codify in the Family Law Act some of the steps and processes that we got from other sources, such as case law, previous cases. So those decision-making steps that we would get from the case law is now codified in the Family Law Act. Full and frank financial disclosure, as I said previously, was in the court rules, so still an obligation. However, that's now being codified into the legislation as well. And we've seen a significant change when it comes to consideration of the impact of family violence. So we did have case law, and in particular, the Kennan case was a case that we quite regularly relied upon when it came to the impact of family violence. But now it's codified into the Family Law Act, and in particular, there's around the survivor's ability to contribute during the relationship. And we've really got to show evidence of that link. It's not enough just to say, oh, I couldn't contribute as much because I was a victim of family violence. We've really got to show the link between the family violence and the contributions. And then when it's being considered for current and future circumstances, well, how is that impacting that person currently, and how is that expected to impact that person into the future? And another amendment was that we're expressly recognising economic and financial abuse as family violence. However, the case law has always said, well, family violence includes a large realm of different types of violence, but it's important that it's expressly codified in the Family Law Act so that, particularly for parties who are self-representing, they are well aware that when we talk about family violence, we're not just talking about physical violence. Next slide. Okay, and let's talk a little bit quickly just about pets, because I know that this one's been getting the most attention, and I have had the most questions about pets and the changes that impact pets. So I'm a pet owner, absolutely love my pets. So I can understand why people are wanting to know and understand these changes in particular. Unfortunately, pets are still not recognised as having their own legal personhood. We'd love to see that, many of us family lawyers, but they're not treated in that way. They're treated as property. However, now with the amendments, they're actually recognised as a special type of property, and we're being provided in the Family Law Act with some more guidance around what a court needs to consider. So a definition has been inserted into the Family Law Act of companion animals, and then we now have a list of specific factors that the court can consider when they are determining who's going to own a pet moving forward as part of a property settlement. So now we have codified into the legislation that the court's going to consider any history of family violence, including cruelty or abuse towards a pet, the attachment by a party or a child of the relationship to a family pet, history of care of the pet, and each party's ability to care for the pet into the future as well. Interestingly, a court can order, so the court can't make orders for joint custody of pets, although we do have some clients that enter into, obviously not legally binding, but sort of a parenting plan for their pet as to when the pet travels between parties. It's not legally binding. So court can make orders for one party to solely own the pet, to transfer ownership to another person with their consent. So that might be another family member, for example, or to sell the pet. And I think that's it. If we could move to the next slide. So we've gotten in just over half an hour, a lot to cover there. I'm hoping that I've been able to provide you with some assistance. I might stay online for a couple of minutes in case anyone has any questions. You could pop those into the chat, any generic questions, but those are my contact details here, and you're absolutely welcome to reach out and get in contact if you do require any further assistance. I know that that's a big snapshot in a short period of time, but I hope that it's been helpful to you to understand how the process works, what steps we follow. But I can't stress enough that everyone's circumstances are different. And I think there can be a lot of danger to people Googling, particularly when it comes to their personal circumstances for their family law matter. So please just be mindful and careful of that you really do need specific advice about your specific circumstances, because as you would have seen from the slides and my presentation today, every matter is different, and we want to make sure that you're getting the right advice.